That makes a lot more sense. Okay. All right, I don't find it to be any kind of a pre-arrest silence kind of potential violation. And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think it, I mean, it's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in. What's next?
The next portion that I have as in conflict was page 386, line 20 through page 387, line 12. And
Is that in dispute?
yes, yes, Your Honor.
Okay.
I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts to explain that he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had with Mr. Thomas prior to his death. Now, whether or not Mr. Thomas said, I'm going to go holler at them, or whether or not Mr. Thomas did go holler at Kelvin is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the conversation was happening.
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
No, it's Donovan Thomas.
Oh, and he was like,
And he's referring to is Donovan Thomas. So,
And I agree with her.
Okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Kenneth Copeland and Donovan Thomas are cool with each other.
Yes.
All right.
Well, I mean, that already comes out in 386 that they had a conversation. My objection is when Kenneth says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up.
Mm-hmm.
Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purpose of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right?
Correct.
Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
I mean, they make their point without, the point that they're claiming to be trying to make is made without that last part.
But sure, I think that gives context when you continue to go further down that page. And when he says, that's what Nut said. And then Kenneth says, yeah. So when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating ring, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar
Yes,
with the
so-
skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of this page in context.
Oh,
But the only way it provides context
is if it's being offered for the truth. Right. I was about to say, so now you're conceding it is being offered for the truth.
Not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying. He definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas that Sunday
Even to the
before.
extent of the discussions about his own brother, it was amicable.
Correct.
And
Whatever.
Okay. But not for the truth of whether he's actually going to holler at him.
Right.
All right. Well, that seems like it's then not offered for the truth. So, all right, that can come in. All right, let's take a lunch break. I know the lunch is here for the defendants, so let's be back. Will it be enough time, you think, to get everybody fed to come back at 12:20? Not 12:20. No, that will not be enough time. 1:20? 1:20, will that be enough time? I'm asking the deputies. Yep. 1:20.
Yes.
All right. So over the lunch break, I did not get a chance to do any of the things that I told y'all I was going to do. However, one thing I did do was work on the further revision of the jury instruction. I saw that the state had sent over a couple of different proposals, and I thought a part of those were good. And I'm just going to tell y'all, I'm just going to read out what I've come up with, which is a little bit from here and a little bit from there. Ladies and gentlemen, my name is Judge Whitaker. Judge Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. I will be the presiding judge in this case moving forward. You are not to concern yourself with this change. And I propose to say, and to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're going to be like, oh my God, did he have a heart attack? Or, you know, so that way nobody's searching on the internet. Okay, then let me remind you, as I assume presiding duties in this case, that none of my decisions and nothing I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. I am only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville about any of the lawyers in this case. To maintain the dignity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the laws I will explain to you. Thoughts, objections?
Anything inconsistent with what Mr. Williams filed yesterday, which I know was part of the file, we would object to. I think that it's important not to say that don't worry about it, Judge Glanville is fine.
Okay, well, I just mean, if you want to come up with another way to say that, that's fine. Do you not want to say anything at all? Just.
I'd like to say what I wrote. He's been removed from the case. That's it. It's not disparaging. It should be disparaging, but it's not. It just says he's been removed.
Well, he is no longer the judge presiding over the case. I think. Pretty much says that. All right.
Can I also ask just a procedural question?
Mm-hmm.
You were very kind in emailing us transcripts like June 7th. Is that, can I ask you, do you know if that's in the record?
It is not yet because it was the rough. Are you talking about of the ex parte?
Yes.
No, when Ms. Weaver sent it to me on request, she said at the time, this is still rough. So as soon as it's ready in final form, I can ask her to file it, but it's not yet.
Okay, thank you. It's just that we've been referring to it.
Sure.
In an appellate court opinion.
Now, it will get in the record.
Thank you, Your Honor.
All right.
Your Honor, with respect to the instruction that you are to disregard comments that were made regarding any of the lawyers, the only concern I have is that, of course, the judge ruled on objections, and in the ruling, I don't know if anyone could perceive any of that as comments. I know it's kind of silly, but it's plausible. And I would ask that the court, with respect to the pattern or the altered pattern instruction, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. Mm-hmm. The court is only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States, rather than.
I am.
Right.
Is that the change you're talking about? Instead of saying I am, say the judge is?
Correct. That, and instead of saying disregard the comments that the judge has made, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another.
So you're saying just say that, don't say disregard.
Right.
Okay. I'm overruling that.
Okay.
So neither side's happy, so that probably means I did a good job.
Will the court, is the court considering, instead of saying I am, saying the court is? I didn't know.
That's fine.
Okay.
I don't think that's a particularly substantive change. All right. So that takes care of that. And we were on I think we had finished the 387 lines 10 through 12, and we hadn't moved on to the next thing yet. So let me know what the next portion is.
Yes, Your Honor. We will actually have to go back a little.
Okay.
Mr. Shannon and I had the ability to meet
Okay.
during the lunch break, and we did discuss those redactions that we agreed with, and there were a few early on that we realized we still disagree with. So
Okay.
the first, Your Honor, is page 266, lines 14 through 24.
Okay.
My stance, my belief is that this goes back to the issue of the hearsay about what he believes, quote unquote, Doug, Mr. Williams, said to other people. And so really the key part of this is the last section. So Doug was like
Yeah.
that gun, you know what I mean? And it just
It looks
we need to know if he has
that, yeah, that's definitely nothing but hearsay at this point, and we have no idea. So that we need a foundation. And that also outside the jury. Agreed. All right.
Your Honor, page 270, lines 4 through 18.
You know, I stand by my objection to this, but in candid to the court, I can't say the page number, but you previously stated that Mr. Copeland's statements that Shannon was in possession of the gun would be admissible over my objection.
Mm-hmm.
I think this falls under the same.
Okay. So you're just making the objection to this part as well. All right. Thank you.
So the next round, I think we're back on track, and we're
Okay.
at page 389, lines 1 through 17.
So,
Let me read it. Give me just a second. Okay.
so if you go to just the last line of 388, just back it up.
Yeah.
It says, they're asking who's talking about the Donovan Thomas case. And
Mm-hmm.
He says, I heard Nard talk and laugh about it. Know what I mean? And he doesn't say what Nard said. So there's
Right.
there's no statement. The fact that I've heard Nard laugh about it, we don't know the context of it, but that may be admissible against Nard, who his name is McMullen. He's on the indictment, but he's not sitting here with the rest of these gentlemen here today.
Mm-hmm.
So we think it's inappropriate to talk about how Nard has reacted or McMullen has reacted to this.
Can I ask, so it's either in evidence or going to be in evidence, all of the people that the state alleges committed this particular alleged crime, right? I mean, the jury's going to know they think Nard did it, that they, the state, think Nard did it.
I would say the state thinks Nard did it. The state in their opening statement has stated as much. I'm standing by my objections about Kenneth Copeland's testifying about what Mr. Darlington said. But that's their stance,
Mm-hmm.
that Nard was there and involved in the car. But, so yes, I would say that's their theory. I don't know what the evidence is going to show or how strong the evidence is going to be, but again, his reaction to this and laughing about it
Right.
is prejudicial to our clients and irrelevant because he's not sitting here with us.
All right, I'll hear from the state.
Your Honor, we do allege that the person he's referring to as McMullen is a member of YSL and one of the individuals who shot and killed Mr. Thomas back on January 10, 2015. And so what precedes this conversation or this portion of Mr. Copeland's, what he tells police is that they ultimately brag about the fact that they killed Nutt, either by laughing or Mr. Williams' sister. We believe that that's a person by the name of Max. We believe that she is an unindicted co-conspirator in the YSL gang enterprise. We have put in evidence already phone records of Miss White, specifically with the Little Wayne bus shooting, that she was in the vehicle following that bus, so actively being part of the enterprise. We believe there'll be a jail call that's going to come in regarding some comments that she made specifically about the murder of Donovan Thomas, basically claiming that they were the ones responsible for killing Donovan Thomas. And so these statements corroborate that ability for this gang to be cohesive regarding a crime that they have committed, and talking about it freely amongst themselves, we believe would show cohesiveness with the gang, would show, and that would be in furtherance of this gang cohesiveness.
Okay.
So now I understand that the state is, the argument for admission is A1B2E. I don't understand how states arguing that Nard, according to Mr. Copeland, saying, laughing and saying, man, F that B, furthers conspiracy in any way. We don't know any of the circumstances around when he supposedly said this, who was around, or how that would be speaking for anyone other than Mr. McMullen himself. And then when we get to Max, who she allegedly said something about, and I guess this was afterwards, according to Mr. Copeland, I don't know. You better not play with my brother. I don't what they think about things. I don't know, maybe Max doesn't like Mr. Thomas, maybe Max doesn't like Mr. Thomas was mad, but Max is not, it's not a statement by a co-conspirator, it's not furthering anything. Max and NARS do not speak for Mr. Stillwell. Mr. McMullen laughing is not an indication of how Mr. Stillwell feels about anything. And neither of these two individuals, Max or Mr. McMullen, are seated here today. So I don't know why it would be admissible against these.
Okay, so, well, because it's alleged to be a gang and it's alleged to be RICO. And I mean, it's, you know, kind of good in contrast that your client never laughed or said a thing about it. And these people are, you know, it's not true. And you can point at somebody not here if you want to or not. But I think under the state's theory, and given that you're telling me evidence that these people are going to be shown to, at least by a preponderance, be part of this gang or associated with this gang, and this is kind of bragging on the gang.
Well, Your Honor, regarding the association with the alleged gang, I just want to make sure I'm clear. Max is not indicted.
Right.
She's not charged.
No.
Really, this is the first time I'm
Hearing that she's an unindicted co-conspirator?
Yes, I've heard that. I've heard her on help calls, talking with people, but I don't believe I've ever heard that she's an unindicted co-conspirator.
Now you know.
And I believe you did during the entire Lil Wayne bus shooting.
Mr. Steele's corrected me and said that they have.
Okay. All right. So, yeah, I'm going to let that in.
Part A, we're complete. I know Part B is probably going to be handled by Mr. Adams, I think. So we have.
Part A and Part B. I don't know where you are now.
So Mr. Shar handled some of these redactions previously, and then Mr. Adams handled the rest of those redactions.
All right. Take it away, Mr. Adams. So give us the next portion we're going to be contemplating.
We're actually going to go from page 413
Okay.
to the end of the transcript.
Ooh, that's a lot.
It was good news. And I believe that I'm really just going to be reciting to you what we've already argued, discussed, and agreed to.
All right.
I don't, and Ms. Hilton will correct me if I'm wrong, I don't believe there's going to be any disagreement about what I'm about to go. But if I can have about 30 seconds just to check one.
Sure. All right. So you're just going to put on the record the stuff that's agreed to.
Yes.
Okay. Sounds good. Pages of lines. Might I ask, if it's already in writing anyway, and y'all can sort out that you do agree to it, if you might just file it instead of reading it out for the next 20 minutes?
I could. What you're actually seeing me flip through our email exchanges between
Okay.
Ms. Hilton and I.
Okay. Well, you don't have to file the emails, but maybe that might be a better use of our time and easier for you.
I'm happy to do that if
All
that's
right.
the court's preference.
Let's do that. Okay.
One
So,
y'all.
y'all. Okay.
Let me just make sure we agree on one point. And speak, and I will follow the court's instruction.
Thank you.
I think we can very well go ahead and I can put an email together that outlines what we have agreed to in terms of the redactions. There is one portion that we may or may not have agreed on.
Okay.
And between checking the transcript of that and also just talking, we can go ahead and resolve that. We don't have to do that right now.
That sounds good. All right. So, and you can just file, I mean, it doesn't have to be in email form. You can just print out here's what we've agreed to and file that.
I'll do that.
All right. So what's our next statement we're moving to?
That was my break.
Apparently. Mr. Adams got the easy part. Wow.
I heard that. So we have the statement on the 21st,
January 21st?
February 21st, 2015.
Okay, right. We've got January 11th, January 28th, February 20th, February 21st, and June 10th, right?
Right.
So this is February 21st.
Yes.
All right, let me get that transcript and y'all can switch to that video to the extent we might need to ever watch a portion of that video. Nice.
February 21st. My best.
Okay.
Your Honor, and I apologize. Never mind.
Okay. All right, so for the February 21st statement, what's our first portion we need to look at?
For February 21st, the first thing I have is page 13, line 19, page 14, line 3.
Okay.
Do you have timestamps for when you said page numbers?
So this has 3:59:50 to 4:20, 4 o'clock and 20 seconds.
Okay.
All right. What's our issue?
Ms. Hilton, I'm sorry, Ms. Hilton, could you say now that I have the time, I wanted to make sure we were talking about the same thing. what, page 13, line,
Line 19 through page 14, line 3.
we got different transcripts.
So is this with Detective Gaither starting, you have it in your mind, we can't do nothing about it?
Yes.
Is that a different transcript? I can email you what I got. I got whatever I got from Miss Weaver.
Please, Your Honor.
Okay, Laura, can
We
you?
have different transcripts, I'm just,
Yeah, no, that'll be crazy if we're not working off the same transcript.
and Your Honor, what I'm going to try to do to keep this moving a little bit, I have a transcript provided yesterday by the court
Okay.
regarding my prior arguments about some of these issues, and I'm just going to try to keep up with the transcript and reiterate what I've argued in the past, so it should be the same.
Okay.
And you have the transcript.
I do. So let me pull that up. Can you tell me what date?
February 21st.
No, I'm sorry. The date of the transcript for this trial where the February 21st statement by Copeland is argued.
It is June 21st,
Okay.
2024.
All right. I have that up as well.
Okay, so if I seem to be arguing something that's not consistent with the transcript, please just let me know it's not intentional. It's just I got too many transcripts going on. But my understanding of what we're talking about here is Investigator Gaither is prodding Mr. Copeland for information about who shot at him. And in this context, it is the February, I believe it's February 19th or 20th shooting that they're prodding information about and asking Mr. Copeland to tell them who shot at him and his child and
Right.
his mother's child. And Investigator Gaither goes through an extended, I'm not going to say monologue because it is broken up, but she is attempting to extract information from Mr. Copeland, and she's talking about the need to protect the community, to keep babies safe, and just essentially makes an argument in that interview that would draw an objection, at least for me, if the state were to make the argument in closing arguments. So I don't believe, I think, the focus, if we're admitting these statements in part, if they are admitted, they would be because they're inconsistent statements by Mr. Copeland. And I don't know how that somehow opens the door to Investigator Gaither to give basically her, thesis on why her job is important and gangs are bad and the community needs to be kept safe by her and her coworkers. So that's our objection, 403, 401. And it doesn't fall under prior inconsistent statements.
Okay, I'll hear from the state.
So previously, Your Honor, when Mr. Copeland was here in court, his testimony in court was essentially, and I'm going to paraphrase, I didn't care about snitching. I didn't care about telling on police. I didn't care about telling the police who did the crime back in 2015. And so this portion of the interview was in contradiction to what he was saying on the stand, because in these 2015 interviews, especially early on, January and February, he would not tell the police who shot at him and his child. And so this portion of the transcript, he's explaining, if I tell you, you can't protect me, you can't do anything. And so Detective Gaither is having a conversation with him about some of his concerns, because this interview, Your Honor, is immediately the day after his first interview regarding this shooting. So he's interviewed on February 20th. And then either in the morning hours or late at night, he's arrested on a probation violation. And then he's brought back in again to further, they're trying to find out who shot at him and his children. And he has extreme concern about telling the police who shot him, actually admitting to that. And when we were in court, his testimony in contradiction to that was, one, that the individual that he eventually says shot him didn't shoot him. He says that in court. And then he also says that he wasn't concerned about snitching.
Meaning, I didn't have any problem with that. I was happy to tell them what happened.
Yes.
Okay.
And so
if he testifies consistently to that, or if y'all decide that you're going to stipulate to any part of the testimony, then this would become relevant as a prior inconsistent statement.
yes, Your Honor.
Okay. All right. But that wasn't the objection from Mr. Sharp.
So even in going to I give that context because their conversation here is the effect on him, what she's trying to tell him in order to get him to actually tell her who's the person who shot him.
Right.
So we're not really worried about her. We're not offering her commentary for the truth of the matter asserted,
Right.
but we're offering it for her, what she's saying, the effect that it has on him in order for him to come forward and finally tell who shot at him.
Mr. Sharp, I'll give you the last word.
Well, I mean, I understand the state's argument, but I don't think necessarily the need to provide context opens up the door to investigators just going in long diagrams.
Okay, well, I mean, it may be that there are other portions of this that we're going to take up. Right now, I'm looking at 13 line 19 through 22, and then basically 14 lines 1 through 3, where she's saying essentially, hey, buddy, you got to tell us what's going on, which is pretty much the beginning of any conversation, interview, interrogation between the police and anybody. And it shows that Mr. Copeland is very hesitant to do that. And so if he ends up testifying, man, I don't have any problem with that, then this, I would think, can appropriately come in as a prior inconsistent statement. I don't see any real other kind of like 403 or anything issues with it. So this is in, assuming obviously the foundation for getting it in as a prior inconsistent statement is laid.
So the next portion, Your Honor, is page 25, line 15 through page 26, line 3.
Okay.
Timestamp 40840 to 40940.
And Your Honor, last time we discussed these, this one, the one we just discussed, the one we're just about to discuss now, and the next one, we discussed all together because they're the same issue.
Okay, well, I'll look.
And you, I think you'll see, I hope you'll see that that Hearsay says more and more, investigator
Okay.
says more and more. They're all the same issue.
Oh, all right. So y'all said 26 line 3?
So page, no, starting at page 25, line
Right,
15.
line 15 through 26 line 3?
Yeah, it's probably more like line 7.
Yeah, okay. That's what I thought. This one looks okay also to me. I am going to let this in. I mean, she doesn't seem to be saying we're the heroes. She seems to just be saying, gotta tell me something if you want it investigated. All right, what's the next one?
Page 28, line 7 through 14.
Okay.
I'm sorry, the time is 4:10:55 to 4:11:05.
Any additional argument, Mr. Shard, on this?
I mean, it's the same thing. It's just we care about, you know, the life of children and those sort of things, and we're trying to put an end to all this. We find that prejudicial.
All right. Any response from the state?
Yeah, I think it's the same thing. She's just trying to get him to tell her who is the person who shot at you. And
All right. Now, if she ends up standing up in closing and starts saying, look at how great the police are, they love this guy's baby, then we'll have a different issue. But just as a part of the interrogation technique going through statement, I'm going to overrule that objection.
the next, Your Honor, is page 29, line 9 through, I think I might have I have page 48, line 11. I think that's a course indulgence. Because I didn't do this. So. Okay, I think it's page 29, line 9 through page 30, line 18.
All right, and what's our issue with this? Is this the same concept, or is this moving on to some other evidentiary issue?
Yes. And I believe Mr. Shar wanted it out initially.
This is more side conversation that is, at this point, I don't believe, well, I know our stance is that just because if the state successfully lays the foundation for specific prior inconsistent statements, our stance, my stance, I believe I stand for everyone, speak for everyone here, is that if prior inconsistent statements are included on a tape, that does not necessarily mean that the state just gets to play the tape. What they play still has to be linked to prior inconsistent statements.
Okay.
And here we're just kind of going and talking about things that are not subject to these prior inconsistent statements. Of course, I don't know what a prior inconsistent statement is right now.
Right.
But I think that there's a lot of fluff in between.
Right. Okay. And is the state proposing to, I've got a prior inconsistent statement somewhere in this 30-minute interview. I'm going to play the whole interview, or are y'all happy?
So the state's position, again, depending on what we do with Mr. Copeland's testimony, he denies, and I think that's what we talked about yesterday. What he says is, I spoke to the police. Everything I said, but it was all a lie. I finessed it all. So we're at a position that I don't know if we have to go line by line, because his general statement here in court is, I may have said everything that you said I said, but I was only saying everything that I said because I was trying to get out of going to jail, because I was trying to get out of getting in trouble. I was trying to get out of trouble. And so a part of it is we believe that we don't have to now go line by line, looking at the Scudder case going, I think it's Scudder, I'm citing the wrong case, going line by line. But specifically as it relates to this portion, we asked him about being a snitch, and this is her trying to explain to him, you need to tell us. It doesn't matter if you're a snitch or not. You need to come forward. When in court, he says something opposite. He says something inconsistent with what he said in his interview.
Okay, so if he ends up saying, I don't know what I said before, but everything I said was a lie, then you can't necessarily just play everything he said. But if he saes, everything I said was a lie and I just said it to get out of jail, and then you say, aha, this shows right here you were willing to go to jail and keep quiet, then that's a prior inconsistent statement to what, if we assume he says that on the stand. But no, you do not. I mean, it still has to be, and it may not be, it has to be like every line, but you can't play an hour-long video unless at least most of that video in some way is inconsistent to what he's saying on the stand. So I don't know if I can, I mean, this is pretty theoretical right now. But
I think we just need to see what he says, while we're, well, because a lot of, we believe two things, not that it's just a prior inconsistent statement, but he's also, contradicting what he says. So he'll testify, at least previously, that he'll testify, they were trying to force me to only talk about thug. They were trying to force me to do these things, and that's incomplete.
that would be,
So
this would show that's not true. Okay, so yes, potentially then, I mean, obviously for all of this, we have to, but I guess what I'm asking is, Mr. Sharp wants to make sure that y'all don't operate under a theory that something in this, and I'm just making it up, I don't know how long the video is, but 30-minute video is an inconsistent statement. We can get the whole video in. Y'all know that, I mean, is that your position?
I think it depends on when he testifies.
Okay, so, yeah. Okay, so then assuming that, I guess we don't have an answer to that right now, but I would not think the entirety of something can come in just because one sentence in it is inconsistent. So for y'all's edification, that would probably be my position. However, assuming that all of this is going to get used as prior inconsistent statement because of whatever he says, we have to assume it for now, like that's why we're going through this, then what other evidentiary objection do you have to it?
Well, I mean, I just keep going back to the same question, which is if the purpose, my problem is all the talking that's, Mr. Copeland isn't really saying anything. It's all investigator gate, and I just don't really understand how we're just giving investigator, and I know Copeland said something, so I'm not trying to mislead the court about the transcript. You have the transcript. But I don't know how we're giving basically Detective Gaither the mic when the purpose is to be impeaching Mr. Copeland with his prior words.
Okay. Well, I mean, I think we got to have the context of what questions he's answering or relating.
To the extent that other people's words may give context.
So, I mean, I would think, that in terms of evidentiary issues, then assuming, which we're doing for the sake of this entire exercise, that it comes in as a prior inconsistency, then there aren't other evidentiary issues that would keep this particular part out, 29.9 through 30.18. All right. So what's our next stop?
Oh, I'm sorry. The next section is page 47, line 9 through page 48.
Okay. All right, what's our issue?
Brenda, we won't object to this portion being redacted.
Okay.
I think it,
She just said she's fine with it being out.
right, I'm not sure. You said it begins at 47:9 on your transcript?
So I'm taking a note that I believe I got from.
He on his Twitter arguing with Shannon.
Okay, you're right, 47:9. Okay, I got you.
Okay. Next.
So the next is page 65. Line 1 through 5. That's what I have.
Okay. Any memory about why this was objectionable?
I think it may have been the program that were used that was confusing. I'm looking at the transcript.
Y'all. Anybody know?
Oh, okay, I know what it is.
All right.
This was my objection, because it was, okay. It was, I think it's likely to confuse the jurors. This is a very poor transcript, but essentially, and you can't really tell from reading the transcript, my understanding is, Investigator Gaither is asking, when's the last time that Shannon and Demekian were hanging out together? And when it comes down to it, the answer is, his answer, it comes down on page 65, line 5. It says, since they shot at the call, and when I hear that, in that context, it seems that he's referring to
They as in Shannon and
Shannon as shooting in a car. I believe what Mr. Copeland meant by that is it was an incident where they were all shot at,
Okay. All right, and is there a redaction that could be made? So what is it that you potentially want this for?
If it comes in, it gives a lot of context. So Mr. Copeland, in this interview, this is now his third interview that he's had with APD, his second with Detective Gaither. So, and excuse me, this is his fourth interview, and I'm saying this in context. In the January 28th interview, he talks to Detective Gaither about the shooting in the car with Demikian and Shannon with him. So when he's discussing right now in February that the only people he hangs out with is Little D and Shannon, and that the last time that he's really seen them since they shot at the car, that's going back to what he's already talked to Detective Gaither.
All right, in this particular interview, have he and Detective Gaither just been talking about that particular shooting where the three of them were the ones who got shot at?
He's talking about collectively everything that's been happening since January 10th.
So no then? Like if you're the jury listening to it, you might be confused when it says they shot at their car.
But this is the only car incident that, when you look at all the interviews.
All right, hang on. So y'all have alleged, I don't know how many different acts in furtherance of a conspiracy, and you've got 8 or 9 different incidents, I'm sure some of them involving cars, where people are getting shot. So it is entirely possible if they hear this that they, the jury, will be confused into thinking, here's Mr. Copeland saying Shannon and Mr. Garlington are out shooting at a car. And that would not be fair to the defense. So is there a way that maybe we can redact out that little part about they shot at the car, since nobody knows who the theys are if you don't listen to the whole 4 interviews in their entirety to know the context of it, so that we don't confuse the jury? Yes, there is a way to do that, is your answer.
Yeah.
Later on in his answer, you're saying, I don't leave the house anymore, I stay away, so I don't think that confusing sentence really adds
anything to it.
Yes, there's a way we can redact this, Your Honor.
So y'all can just redact out that part?
Yes.
All right. So that is 65 line, is that 65? Yeah, 65 line 5, the part that says since they shot at the car. So the rest of it's fine, right? Is the rest of it's fine, Mr. Sharp, essentially?
Yes.
Okay. Next.
The next part we have, Your Honor, is page 155, line 1, through page 156, line 20.
Okay. All right. I'm ready for argument.
The issue, Your Honor, is, so, little context. There's a shooting at a gambling house, where by this time, Mr. Copeland has determined that an individual by the name of Kelvin Watts, as well as some of his friends, I guess, were responsible. And I think Mr. Copeland was allegedly shot out. I think Mr. Williams was allegedly shot at or present in the gambling house. Maybe some other individuals as well. Mr. Copeland tells a story, and it's tough to really grasp from the transcript, but no one knew who did it. According to Mr. Copeland, no one knew who did this shooting. It was supposedly, and everyone thought it was another group called NBC, who had jumped Demekion Garlington on that same day at a club somewhere. So the thought was NBC was responsible for shooting the gambling house. Now, by this time on the interview, Mr. Copeland has determined it was Kelvin Watts. How did he determine it was Kelvin Watts? What's his basis? Okay. Well, Kelvin Watts was apparently dating a lady named Trevia, who Mr. Sledge also dated. So the flow of information, as I understand it, is Kelvin Watts, according to Mr. Copeland, Kelvin Watts tells Trevia that he was responsible for shooting up the gambling house. Then Trevia tells Mr. Sledge, and then Mr. Sledge tells Mr. Copeland. So these are not observations based on Mr. Copeland's firsthand knowledge. These are, it's like game of telephone at this point. And he was under the impression that it was NBC based on speculation. So, you know, if Mr. Copeland gets on the stand and starts talking about what he saw at the gambling house that night, that's one thing. My understanding he was there, but to say who did it and all the rest is just layer and layer of hearsay. And then on top of that, he's talking about Mr. Garlington being jumped at the club by NBC, and my understanding is Mr. Copeland was at the gambling house and not at the club, so I don't know what his basis of knowledge on that is either. So he's talking about two different things that he doesn't know. Okay.
So I'm not sure what the Shard saying. He doesn't know about the shooting. He does know about the shooting because he was present at the shooting. So the shooting.
Right. For that, it's who's responsible for it might be hearsay on hearsay on hearsay. What do you say to that?
Well, what he says here now is that Gucci, he found out from one person, which was Gucci Red, and that is not Trevia Smith. That's two different people. Gucci Red and Trevia are two different people.
Okay, so where's the part where he says, here's who I knew it from?
So if you go to page 156, round, it says unintelligible, so you need to hear it. But it says Gucci Red. I can play that portion for you.
What part of, give me a line number.
Line 17.
Okay.
And if we skip to line 15, says, goddamn, the next night we at the gambling house. They ain't putting no picture. We in there gambling. They taking pictures and shit. Then they came up and shot at us. Only reason we found out it was Kel, he had got into it with Gucci Red. And then she talked to them and she came back and told us, like, man, that was Kel and them that shot y'all. Make it seem like they did because they shot it up.
Okay.
And then they went and shot at another spot. And then Monday we got into it with NBC. And then he goes on to talk about whatever happened between them and NBC. So whether or not Gucci Red told them that Kel shot at them is irrelevant, because what this incident at the gambling house does is kind of form the basis of other events that happened after the gambling house. So some key incidents early on in this conflict between YFN and YSL is there's the gambling house shooting, and that becomes important because after the shooting, I believe it's the next week or the next day at Cascade Skating Ring, Kel, who's the person who shoots at them, and Mr. Williams have a phone call in the presence of Copeland, in which Mr. Williams wants Kel to pay for his car window. So this, whether or not Gucci Red told him doesn't matter. It's what happens afterwards, which is the impetus for this conversation about paying for the car that was shot up at the gambling house.
Okay.
I mean, in other parts in the discovery, it's the flow of information is described as different, but either way, if it comes from Gucci Red, it's still hearsay.
Well, it is, but they're saying they're not offering it for the truth. Right?
Yes, Your Honor, it's the effect on the listeners, which everything that happens after it derives from them knowing that it was Kel who shot at.
All right. So if that's the only objection, then I'm going to overrule that objection. Okay.
Next, Your Honor, is page 173, line 7 through page 174, line 2.
Okay. All right, Mr. Sharp, you want to articulate your argument?
And Ms. Hilton, you said it ended in 174 too?
Yes, sir.
I'm just trying to get it. We'll withdraw that.
All right.
Next is page 181, line 8 through 12.
All right. Any
we
chance we can just get rid of that?
Yeah, we
Okay.
have an objection to that.
There we go.
last one we have is page 185, line 17 through page 186, line 19. And you're right, we're okay with redacting.
Entirely? Just trying to get clear what you're saying there.
Yes.
Okay, so that'll be 185, line 17 through 186, line 19 will be out by agreement. Okay? What's our next portion of this transcript?
That's the conclusion that we have.
Oh, okay, well. Okay, what's our next statement we're moving to?
We can do February 20th.
Okay.
Send me the transcript.
And is there an associated trial transcript where y'all are arguing this that might be beneficial to look at? I mean, we didn't end up using that other one very much, but. I mean, if you're not going to be using it, then that's fine.
Well, I'm trying to remember. I haven't seen this transcript.
Okay.
And February 20th may have been earlier before the break.
Oh, well, hey, then we don't need to rehash that one.
And that's what I'm trying to figure out. But for January 11th and February 20th, I'm trying to figure out when we had those arguments because we actually played those videos on the.
Okay.
Right. We haven't received the transcript when we discussed January 11th or February 20th, so I don't have an independent recollection of what they argued.
And those two had the minimal. We agreed on most of that.
Okay.
The actions that came out, we agreed on.
And they've already been played. Y'all just aren't sure whether it was pre or post recusal motion. Is that what you're saying?
Yes, those two videos were played. Let me back up so the record's clear. The video for January 11th and the video for February 20th were both played in front of the jury.
So,
At least on the 14th and I believe on the 17th of June.
Okay, but
I assume that the argument may have happened.
okay.
I don't know if the argument happened post the 12th.
Right.
I can't recall, or if it happened pre the 12th. That's what I need to determine.
So I have some notes.
Okay.
That were taken by Tim, who, I have that the June 11th interview, excuse me, thank you, January 11th interview was played on the 17th. And the February 20th interview was played on the 7th. So those were played after the motion. I just want to make sure. What does this mean? Okay. It looks like portions of the January 11th were played before. A very small portion. It's like 30 seconds of it.
Was played before what? Okay. So would that indicate to y'all that y'all had already hashed out the evidentiary issues with regard to the January 11th statement prior to the motion to recuse being filed? It would indicate that to me, but did you at least do the entirety of this January 11th statement at the same time? By which I mean, that was not at all clear. Did you handle the evidentiary issues with the January 11th transcript all at the same time?
I knew what you were asking. I don't know the answer to it, and this is why, because
Okay.
and this matches my recollection. This Hilton used the January 11th was one very particular point that she played like 30 seconds
Right.
to Mr. Copeland. So I don't know if we had reviewed the whole, and she also played a 10-second clip of the January 28th interview before the motion to recuse.
All right.
And a 12-second clip of the February 20th. But I'm trying to see if there's any note about when we discussed reactions.
So I know that after the jury leaves and hasn't yet come back, y'all discussed the January 21st and the February 21st one, so y'all had not done those pre-interview. I'm not helping, am I? I'm making it more. Okay, yep, no, I don't know what that means. February 21st. I don't know. So, if y'all don't know whether you dealt with all of January 11th at the same time or not.
So, Your Honor, initially, I impeached Mr. Copeland as the issue or the topic came
Right.
up. Then when it turned to everything's a lie, then we went to
Okay.
getting in the entire statement.
Okay.
Or playing the entire statement. And so when we had argument.
All right. So you spent a lot of time after the
Down there.
Yes, yes.
I'm looking at notes for 6/17/24. We sent redactions regarding. We were discussing redactions, I think, on the 17th regarding January 11th, January 28th, February 20th, February 21 interviews. That leads me to believe that these were not redacted prior to the 12th.
Okay. Well, y'all said y'all are close on those anyway, so why don't we just
So I think
If it's me revisiting and ruling differently, then maybe lucky state, maybe lucky defense. Who knows? I don't know.
So I think the next video we can actually go to is January 28th, because that is where we had some more redactions.
So are y'all just then, as to January 11th and February 20th, y'all said, I think, that there isn't much y'all disagreed with about that anyway?
That's my recollection.
All right, so maybe y'all can get to huddle up together on those two, and maybe y'all can come to agreement. If not, you can either figure out, was the ruling made before the motion to recuse, or if there are two or three things and we don't know when the ruling was made, just bring them to me.
Yeah, sure.
Okay. Okay, so then we'll move on to February 28th. Is that what you said?
January 28th.
January 28th. Right, February 21st, January 28th. I am just making it that much more confusing. Sorry, y'all. Mr. Harvey's going to use that later when I say that. Even the judge admitted it. I'm teasing you, Mr. Harvey, although I bet you will. Okay, January 28th.
Yes. So,
And that has either not been discussed or it was discussed post-recusal motion.
discuss post-recusal.
Okay, and so do we need to look at a transcript, or Mr. Shart, you're just gonna?
If the state has a transcript of this motion, this interview.
February, January
I'll let
28th.
it work up the same.
All right, we can, I assume we have the one that, ours came, I don't know where ours came from, if they came from Ms. Weaver or from the state, but Ms. Percefield will forward you what we have. Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back at 3.
Your Honor, can we have just 3 minutes? I think we might be able to get through this much quicker. So you're on the first time that we have, we're at issue is page 42, line 3, through page 44, line 8.
Your Honor, that this first segment that's in dispute is a discussion about possible, quote unquote, beef between Bloody J, who is, his name, last name is Usher, and he is allegedly a member of IF, or an affiliated subset of IF, and he's a rapper. And I think the state's theory in some ways is that there was simmering beef between Bloody J and Mr. Williams, because Bloody J said some things about Mr. Williams, Mr. Jeffrey Williams, I should say, and Mr. Copeland goes on to say, well, they say that Birdman Williams, Brian Williams, aka Birdman, wanted to sign Bloody J, but Jeffrey Williams didn't want Birdman to sign Bloody J because of the feud that they had between each other, and he was blocking Birdman from signing Bloody J. So that's the background. But the bottom line is Mr. Copeland saying they said that Birdman wanted to sign Bloody J. There's absolutely no indication. My understanding is that Mr. Brian Williams is a multi-millionaire who runs a big record label. There's absolutely no indication that Brian Williams is running his ideas of who's going to sign and not to Kenneth Copeland. And Kenneth Copeland's just kind of, and he says it. He says they say this, they say that. And so that's all hearsay from our perspective. It's all speculation. It's not based on understanding. And Brian Williams is on the state's witness list. So if they want to call Brian Williams and ask him about what his plans were to sign Bloody J, but Mr. Jeffrey Williams did allegedly stop it, they can certainly ask Brian Williams.
And Your Honor, the state has no objection to page 43, starting at line 4 through page 44, line 8. The only portion that the state wants in is page 42, line 3 to page 43, line 2. Mr. Copeland, it's either in this interview or one of the other interviews, talks about how he actually brought back, or he tried to get Bloody J and Mr. Williams to kind of at some point start working together again. So he has some familiarity, we believe, with the relationship between Mr. Williams and Mr. Usury. So when he's on page 42, when investigator Dennis asked, so what happened with Buddy J? Weren't they cool? He explains his understanding of when they may have started to fall out. This transcript is not the best, but some of what I believe is in this transcript, if you go to line 12, when you said you was trying to hook them back up, what happened? Like, did they fall out? Was it a beef or something? His response, I think they did because Bloody J joined they gang. Whose gang? If gang is what it actually says.
That's not saying game.
No, it says,
It's gang, G-A-N-G.
and it's saying if gang, I-F gang. He says, and I guess he was down with YSL, and I'm at line 23, and then it says, you know what I'm saying? So he joined them. And so that's his understanding of where their beef started at some point between Bloody J and Mr. Williams. And this is corroborated, Your Honor, because we have video evidence that at least back in 2012, Mr. Williams and Mr. Ushery, they're releasing music videos together. At the time, it looks like it's a ABG or Atlanta Blood Gang music video, but they are friends. And we know that the friendship dissolved sometime after 2012, which will corroborate or lean into what Mr. Copeland knows about their relationship. So we that's the only portion we wanted in, which was page 42, line 2, up to page 43, line 1.
And so I understand the objection to that being this, for all we know, is hearsay about why they fell out.
I think it's the way that he speaks, and if you watch it, it doesn't seem like he's saying they, like this is something they told him, because he says, when you said you was trying to hook them back up, what happened? Because he was trying to bring them back together. So it seems the state understands that he has personal knowledge of how the relationship dissolved, not something that he overheard but something that he's.
Why don't we just maybe find that out?
Yes.
Additionally, if Mr. Copeland, outside the jury's presence, and has personal knowledge of it, then that's.
The next portion that is in disputes, Your Honor, is page 203. Excuse me. I need to find out from Mr. Shard if he looked at what we discussed of 80804 all the way through 81150.
Can I back up on one? My notes may be wrong. Did you agree to number 5? 750 to 750?
Yes, we're not going to contest that.
All right, so where are we now?
80804
And
to
those are
8.
the timestamps.
So roughly page 178.
This is a big one, Judge. We agree from 80804 to 80912.
Right, and I don't have the
So
timestamps, so.
page 178, line 7 to page 180, line 8.
And the state wants to go beyond that. And what happens after 180, line 8 is very interesting.
Okay.
This is January 28, 2015, at this Crocus speak. He spoke on January 11, 2015, speaks on January 28, 2015. February 20th and 21st, 2015. And then on June 10th, 2015 is the first time he says that my client and other individuals are responsible for Donovan Thomas's murder. In this segment right here that the state's wishing to redact, they ask him about who he thinks or who's responsible for Donovan Thomas's murder. And he says, well, what my understanding is, or what I've heard, now mind you, his stance on June 10th is he knew that my client and others committed this murder that night. So he was in knowledge of it that night. Right. On January 28, 2015, they're asking him, who's responsible for Donovan Thomas's murder? And he says, well, I believe, or I heard, and I'm not asking him to do it for the truth of the matter asserted. I'm asking to show that his story's changed and he didn't say it initially. He said, well, I heard that Kelvin Watts had robbed someone and then Donovan Thomas was murdered as a result of that. And I believe, I'm not going directly off the transcript, but he puts forth different theories on what happened to Donovan Thomas. And our stance is that's important for the defense because if he was a truthful person who was telling the truth, he would have said that then. Now, the other interesting thing is on all these other dates that he's given these statements, he's not facing arrest. It's not until he's facing arrest that he points his finger at my client and others. So to us, that's a very important fact. And it's not being offered for the truth of the matter asserted. It's being offered to show that what Mr. Copeland has said at different times, when common sense would dictate if he's being a truthful person, he would have said what the state's saying the truth is.
All right, are you sure this is 178, line 7 through 180, line 8? Because I don't see this being about any of.
So that's the part we agreed on. And then they want to go beyond that. And starting at 180, about 180, line 8. And we want to keep it in.
So 180, line 8 through what the state wants out.
Until 186, line 2.
Mr. Hill, could you just, where you want to stop?
Page 186, line 1.
And the transcript doesn't really.
We can listen to it. And why, I mean, maybe at the gist of it, why does the state think it
We,
is to be excluded?
because it's a lot of rumors. This is actually not him testifying from personal knowledge. When he first starts on page 180.
So I would concede it's not personal. I would concede that's not personal knowledge.
So I think that they can cross-examine him on whether or not, why didn't he tell the police early on, but all of his speculation about what the rumors are is irrelevant. That's putting in information in front of the jury that's based on speculation and rumors. If they want to cross him and say, on January 28th, you didn't disclose that any of these people did it, I think that's fair for cross-examination, but to actually introduce this statement of him speculating as to what may or may not have happened on the night of the murder, it's just that, it's rumors and speculation.
There's a fundamental difference between not coming forward with information and being asked about something and coming forward with other information.
Maybe I need to listen to it, because I don't really see in this transcript at least, except for on page, the very end of 184 and beginning of 185, maybe? And I'm not even sure if that seems to be the only thing they're talking about, not getting killed.
The beginning part of what they want out, and so there's after the part with our agreement, they talk a little bit about an incident where Kelvin Watts shows up at Lucci's mother's house after it's been shot up with a gun.
Yeah.
That is a separate, so I don't want the court to be confused. That is not the nut.
Right.
The Donovan Thomas murder.
Okay, so do you want that part here?
I do want it in. If you ask me why it should be in, I want it in. But the reality is, I don't believe that Mr. Candid to the court, I don't believe that Mr. Copeland has firsthand knowledge of that, and that doesn't really fall under my argument about the Donovan Thomas.
Or then you agree that we don't have to talk about that part, so point me to the part where we actually, that you, the defense for Mr. Stillwell, want in and think appropriately can come in under the
Respectfully, I think we need to just play it, because I can't, the transcript is so long.
Okay, yeah, no, I mean, I think so too, but certainly it's not that part about Lucci and Lucci's mom. All right, so can somebody?
Yes, so I'm going to start around, as I heard, we were at 8:08:30, which should reasonably be somewhere on page 179, probably around line 7.
Where she was, she can come out, and then this like Rich on the corner throw ahead show. And I was there, and Rich on the corner came, but Rich on the corner tried to play both sides. So
he like the kind of like.
Yeah, so he just like bro, man, I'm tell you how serious it is, bro. Kill try to kill anybody, bro. He told me to call Max and tell her, trick her down here so he can kill her. Just to get back into it. Yeah, he said like he want to kill somebody that way gonna hurt. What the hell? Do what he's saying. But Rich on the corner, you going right as hell. Lucci ain't gonna pay his bond. They said he made a Lucci because Lucci ain't pay his bond.
Why? Why Lucci ain't pay his bond?
But what don't make sense, let's say, okay, what word did we get, right? Somebody said that Kel was called over there to the house after he got shot up. So at Lucci Mom's house? Yeah. All we heard was Lucci Mama's house got shot up. Kel pulled up with the guns. They would come to the tree. Kel pulled up with the guns in the car. And police walked up, searched the car, found the gun, locked him up. But why
was he there? Who brought him there?
I don't know.
Lucci Mama's house. Kel
They probably, you know.
So if that's the case, and then he got locked up, why did Lucci want to pay his bond? You know what I'm saying? If I basically
Called you and said, yo, my house got shot my town.
check on,
And then the red Camaro Lucci got,
yeah,
the same color they ran around, they shot my girl mama house up. They Lucci cup.
yeah.
You know what I'm saying? But I ain't get it. You know what I'm saying? They got my name on so much stuff. Like, people that come and tell us, they tell us little bit, then they start talking about it's me. You know what I'm saying? Like, my girl, she get a lot of information from her friends. She got a lot of friends, so they be around me. Lucci and them was talking in the studio, and it was a girl in there. They missed one of them, and she my girlfriend. And she said that ain't nobody do that. Nothing. You know what I'm saying? They was all like Kill and K robbed somebody. You know what I'm saying?
Kill and who?
K.
Who's that?
I sent you a picture of that too then. I think I sent to those pictures. They had chop on in the picture. Oh, yeah. And the them was in the car. Yeah, them two robbed somebody. And they supposed to came back. This was they talking about in the studio. You know what I'm saying? They just put my name on it. They covered it up. Niggas seem like they ain't got beef in the streets, whatever. Yeah. And then they like, she be like, they know we can't do it. You know what I'm saying? But they gonna keep playing on him. And she be like, K, when the nigga got killed, K first one called everybody. I'm like, we killed Nut. We killed Nut. Tell them on there what did. He the first one started my name. And they like, Kill went along with it. So they had Jerry Ross, like, then they did. Like, Nut died, then they started. That same day? I don't know when. They like, they just Ross, man. And niggas supposed to be coming back for them. You know what I'm saying? Like, Kill Ross, Fly. He robbed one of them. Like, and then, like, they would have somebody broke in that cup. And gave me the phone. And the jury.
Stop moving at 8:11:50. So, Your Honor, and look at a lot of it is these just rumors about what he's hearing about what happened leading up to the murder.
I don't even know if they're rumors that he heard. He might be completely making it up and never even heard a rumor, but that's besides the point. They're asking what happened, how did Nut get killed, and he proffers a theory or a story that Kel and Kay robbed someone, and then those people came back and killed Nut. And that is, and the relevance of that is it's not for the truth of the matter asserted. I don't think anyone in this courtroom, at least on this side of the room, is going to get up in closing and argue that the real killers of Donovan Thomas were, I'm hearing the name Nick, and maybe I'm following the story correctly or not, that Nick, after being robbed by Kel and Kay, came back for revenge and killed Donovan Thomas. We're not arguing that that's true. What we're saying is simply that, according to the state's theory, Mr. Copeland had inside information on January 10th, 2015, and about our clients committing a crime, and then he's asked about it on January 28th, and not only does he not, it's one thing not to mention our clients, which is important, but it's a whole nother thing to put a different theory out there. And so we think that's very relevant, and that goes to his credibility. And I understand he's arguing to everyone that he has no credibility, but the state is arguing that there is credibility with his June 10th, 2015 statement, and we're saying there's no credibility to that either.
So that's not saying, Your Honor, I don't think the two are not mutually exclusive. He can know the truth, the proper rumors, but what those rumors are is they're not competent evidence. Like what he's saying, they can cross him without this coming in about the fact that he told the rumors. You told the police rumors in January. What those rumors are is not competent evidence because it's all speculation. It's all rumors. But they can clearly ask him that on the stand without going into.
All right, and I assume that the only reason June 10th comes in anyway is
because he takes the stand and says, I don't know anything about anything, I don't remember.
Right.
And so June 10th comes in as a prior inconsistent statement.
Yes, Your Honor. Because prior to everything, his response is everything in June 10th, again, the whole finessing, and then he's now changing the version of facts as to what happened back in January 2015. He's now changed some of those facts. I don't know what he will do when he comes back, but that's what he can do.
Standard for defense. If the state can stand up and go, all right, here's your prior inconsistent statement where you said X, Y, and Z, which was all these people over here on this side of the room killed them. Then they want to be able to say, well, look, in January you said something different. Explain that. Why shouldn't they get to do that?
I think they could ask him about, in January, you said it was all rumors. You said that. You said that there were rumors. What those rumors are, I don't think is relevant. They can definitely ask him. Now, whether or not he says, I never gave anyone a rumor, then maybe that might open the door for something else. But for the state to play it initially, if we even get to play the statement, all these rumors coming in, I think there would have to be some foundation about the substance of the rumors if they come in. But they can ask him simply on the stand, you told rumors, and if he says yes, then that's it. What the rumors are will be irrelevant.
We've all been doing this long enough to know that one of the things that makes stories ring true sometimes is the inclusion of detail. No, it'd be one thing if he just said, John, I heard John killed Donovan Thomas. But he didn't do that. In this story he gave, he gives details. He gives a story, a coherent story. And that matters. It's not just that he gave rumors, he gave a coherent, detailed theory. And the state, I'm sure at some point, is going to argue to this jury that, oh, well, he was telling the truth on June 10th because look at the details he gave. How would he ever come up with this story that was these specific 4 gentlemen in the car? How would he ever, and we're seeing on January 28th, he is giving a detailed story with individuals and a motive and all the rest. And so I don't think that it does. I think something is lost if we were limited to just say, oh, well, you talked about rumors on January 28th. That really doesn't do it justice. We should be able to get into exactly what he said. And again, we're not going to argue that that's the truth. We're just going to argue that it's Mr. Copeland's ability to think on the fly and come up with detailed stories. And when he was given an opportunity to to explain what happened, he came with a detailed story that had nothing to do with our clients. We think that's fair game.
Well, I mean, you can certainly ask him about it. You can ask him in as much detail as possible as you want to. And I think it's going to depend what he says then.
Oh, well,
whether.
Well, okay.
Oh, me? Yeah, sorry.
So maybe if you're saying, I'm not presuming that he's going to deny saying this. So yes, if we ask him on the stand and on cross-examination, leading questions, and he confirms that on January 28th, he told about
this
all
story
that stuff,
about,
then
right.
I can see that we wouldn't
That's it.
necessarily
Yeah.
get to play.
Okay.
But I think, as I understand it, the state's saying that we don't even get to go there.
Oh, no, they're not saying that. You agree they can cross him as much as they want to on, hey, this was your theory or rumor or whatever that you told the police on January 28th. They can ask him about that, right? I mean, you agree to that.
Are you asking if he can say, this is what I told the police?
can they say, do you have a dispute with them being able to cross Mr. Copeland and say, well, on January 28th, when you were talking to the police, you told them that you heard from the street that Kay and whomever robbed so-and-so, and it was those people that then killed Nutt.
So the state's concern is, even in the interview, he doesn't say it as fact. He doesn't say, this is what happened.
Well, sure.
He said, this is what I heard.
Yeah.
So to me, it's still speculative as to what he heard on the street. Whatever the rumor was, to me, is still speculation. I think an inquiry could be, you didn't tell them on January 28th that Shannon, Stillwell, these people did. You only proffered rumors, not the...
But they can, so you think they can ask, you told rumors, but they can't ask, what is the rumor you told them?
Correct.
That is not correct. You can, in fact, ask them about the detail of the rumor that he told them. As long as, I mean, obviously he is clearly saying this is a rumor I heard on the street. And I know your point's going to be, well, that's an awfully detailed rumor. And you could argue that later. But yes, you can get into the detail of, didn't you tell them you heard X and Y and Z? And then if he says, yeah, I lied about that too, then that's the end of it. If he says, no, man, I never said a thing like that in my life, then we may be able to actually play that part.
That's fine. We still believe that the rumor is speculation, but we
No, it is. I mean, he says it is. He says, this is what my girlfriend told me she heard from somebody else. It's clearly a rumor. That is not their point. Their point is, you, at some earlier point, are telling the police some theory, albeit rumor, albeit street talk, that is some details. And I think they're going to argue whatever they're going to argue, but they can get into the substance of what that rumor is. They can't mislead that this is what you said as fact. It has to be still, this was the rumor you told them, but they can get into the detail. Mr. Steele.
Well, I think what you just said is what I want to ensure.
Yes. Okay.
I think we're good. And Your Honor,
he's just saying I'm standing up because I wanted to make sure that you already just explained what I was going to ask about.
But the one position is, you know, you may know this, but Mr. Copeland didn't say, like, I never said anything. What he actually said was,
I said all of I don't remember exactly what I said, but everything I said was a lie, right?
exactly.
Yeah.
Because the police were making me the number one target. They told me I'm the subject of this murder, and I wanted to push everything I could away from me and onto others.
Mm-hmm.
So that's why it's very important to show that he's just coming up with, you know, Mr. Lamar is Rich Homie Kwan. He put a hit on another person to kill them. Ask Mr. Copeland. He has 17 people that he says put hits on other people.
Okay.
That's outside of people here.
Okay.
But what you said is exactly right. It doesn't matter. I'm not using it for truth. I'm using it for exactly what he's saying. That's what I was doing.
Okay.
And at trial, he said, and that's what I did for the people here on trial.
Okay.
Thank you.
All right. What's our next portion of this transcript at issue?
The next,
Or statement.
the next part that's at issue potentially is page 203, line 11 through page 206, line 17.
Okay.
And more specifically, page 206, line 15. To line 17. Mr. Shaw, are you okay with 8:21:31 through 8:21:37?
So that's 206:15 and 17. So
Yeah, that's going to be page 203, line 1 through 16.
okay, I mean, Your Honor, could I just inconvenience the court and ask that 15 seconds or whatever that is potentially in dispute be played? Because I don't think I have an objection, but
Okay.
I can't really tell from this picture.
Okay.
If I could just hear it.
Sure.
And Your Honor, I'll play from 8:21:31 to the whole section.
Okay.
Me and G together don't matter what. Just like DB. We work together. You know what I'm saying? We not doing that.
Who killed DB?
They don't even, man. They don't
Who you think?
Y'all know. Fred.
Killed DB.
They don't even, man. They don't
Who you
even.
think?
I think you started right after
The portion.
yeah.
Man, besides Shannon and G, you ain't gonna see me hang with nobody.
So is it a person that they hate you?
No, that's what I say. How the hell I be leaving all the time? Everybody after me. Like, it's not one man. It's not one time.
All right, I'm fine. The state wanted to play that, and I don't have any problem.
Okay.
So right after that, we're in agreement from, I believe, 8:21:37 to 8:22:52, where the murder of a gentleman by the name of DB
Mm-hmm.
is discussed. I
Yeah.
believe what we agree that is coming out.
Okay.
And then if Ms. Hilton could just play the 7 seconds that on the other end of that she wants to include, I just want to make sure.
All right. So this is going to be somewhere on 206.
Yes.
Okay.
Somewhere, or starting at line 5 or line 6.
Okay.
It's going to start a little early at 8:22:02.
Okay.
He just threw it up. He did kill me. He's tough. I know, but just like you said, somebody that might put him on the team. That's about what you can prove. Like, just like the little nigga, Lil Haiti. When he just got out of jail, he see me in the club. He walked right up on me. I'm murdering me. Yeah. Who? Little nigga, Lil Haiti. You know, who's supposed to have something to do with GB. Oh, okay. But then he walked up on me, nigga, who the hell is you? Yeah. I ain't know him. Yeah. What's up? Best friend, what's up? Why you looking at me like that? Yeah. And me by himself, like, I know my little brother, Lil Haiti, he just got out. So I'm like he booked, like, nigga, shit up. Nigga, like, what's up?
Hey, Lil Haiti, the one that got shot in the back?
Yeah.
On Boulevard, right?
Yeah.
He out too?
They him. Like, I don't
So they,
some corn got a video on his page. How they walking in the house. Same night he shot my grandmama's house. I know just all the nigga they did. You know what I'm saying? They pulled up their store house in 3 cars.
so you mean, after this, so it's Rich Homie and Thug beefing?
Nope. How is that not possible though? That's what I try to say. I feel like
He playing both sides.
I feel like everybody like I feel like
when he needs.
I feel like they came together and made an agreement to kill me and everything go away. I feel like it. But I'm not gonna run.
Even when
We're past it, and Your Honor, that portion we can keep out.
All right, so what is the portion that is at issue?
No, nothing, ma'am, now that.
All righty, I'm glad we all did that.
82259 is where we're gonna go back live on the state. It's playing.
So the full redaction, 82137 through 82259.
Sorry, repeat that.
Sorry, the full redaction will be 82137 through 82259. And that's going to be page 203, line 19 through page 206, line 17.
Okay.
We have a series of agreements, Your Honor, and I think there's only one more that we disagree. Is that correct? And it's only apartments.
Okay. Where's that?
Page 269, line 19 through page 270, line 14.
All right, and is this a part that the state wants in, defense wants out, or the other way around?
Right, if I can do one more time, this might not be.
We both agree that a certain part of this comes out. There's a portion of it where Mr. Copeland somehow talks about a rumor that Donovan Thomas in his dying breath said that Doug was responsible.
Okay.
A, that's not true, but B, that's hearsay. People that were next to Donovan Thomas said that's not true. So, but it's hearsay nonetheless. But I believe that the state wants to not take out a certain segment of this, and that was our disagreement.
We are fine taking out that part.
That part being,
Sorry, what Mr. Jarvis mentioned that Thug did.
okay.
That part we will keep out. We didn't know if the defense has other objections to, and I'm sorry, Your Honor, we're on page 270, line 7. It actually says, he said Thug as has something to do with it. It's unintelligible, but that is the line that we're referencing.
Okay, so y'all are by agreement taking that out.
So, but I guess at the bottom of 269, we have it written down as 269, 19, 270, 14. Is that correct?
That's what I wrote down, but what y'all might have an objection to, I don't know.
Well, okay.
So, (269:19 through 23), where he's saying some detail about what he heard about not getting shot. Is there any dispute about whether that is in or out? I mean, I don't know, y'all.
I agree that is out. My understanding was the state viewed that those timestamps were too large and that something within that time period can get in, but
Okay.
maybe not.
All right, Ms. Hilton, was that something y'all intend to put in?
Initially, yes, the Honor,
How about now?
we will not put it in.
All right, so then 269, line 19, all the way through 270, line 9 is, I'm sorry, 9 or 14 is out by agreement. Which one was it? The end, 9 or 14? No. Okay.
Page 270, line 9.
Line 9. Okay. Yeah. She is out by agreement. All right. So was that the last thing?
Yes.
Okay.
And Your Honor, our agreements for redactions, I guess they'll just, when we email them, they'll be made part of the record that way?
When you email them to whom? What I'd like y'all to do, I mean, for this, we actually, anything we didn't discuss that y'all have an agreement as to, like all of Mr. Adams' stuff, just make a little list and say, the state and the defense agree that XYZ is out. Okay?
Here, I already compiled it from the first time.
Super. Just get together with your colleagues on the other side and make sure they agree and get it filed. Okay, so that's that statement. That's the January 28th statement is taken care of. And y'all are gonna, on January 11th and February 20th, figure out the couple of little things that might be in dispute and then bring those to me. And I doubt if y'all got a chance to do that already. So it seems like then the next statement is June 10th, right?
That's what we did this morning.
That was,
We started with June 10th.
We'll go in reverse.
We went over.
oh, right, okay, you're right. So if we've done
all the 3 that we can do.
and, okay, and then the other 2, y'all are just gonna figure out what the small little differences are. Okay, so then I think the next thing we have to sort out is with regard to the testimony of Mr. Copeland that occurred post-recusal motion. I don't know how many days of transcript of that y'all have yet. I think you have at least 2 or 3 days worth of that, but maybe not all of it from Ms. Weaver, Judge Glanville's court reporter. Some directly from her, some through Ms. Firstfield. Because, right? Have y'all discussed that at all yet?
So Mr. Shannon and I discussed briefly that the defense needed to talk amongst themselves.
Okay.
And then they were going to come.
All right. Okay. So over the weekend, y'all figure out both amongst yourselves and then between the defense and the state, if there is anything, and if there is, what, of Mr. Copeland's post-recusal motion testimony, there might be some agreement to. And then also, if y'all can think and propose to me on Monday, whatever y'all think might be appropriate in terms of explaining to the jury if they're going to have to sort of rehear any part of Mr. Copeland's testimony, you know, just what we're going to tell them about that. Okay. And then after Mr. Copeland testifies, what's next? And how long do y'all anticipate that taking? Y'all have no idea, do you? Because who knows what he's going to do.
That part is true. Does the court mean like which witnesses?
Yeah.
Okay, so I anticipate there will be 2 other potentially Mr. Sledge, Mr. Zachary,
Okay.
Those two.
This is what you gave me. That's basically an order, right?
Yes.
Okay.
Yes.
So then, Mr. Sledge and Mr. Zachary, are there anything about their evidence that we need to hash out? And I can't remember, what did I give you as your deadline to give us all the details about the evidence?
You said the exhibits was Wednesday, but then the witnesses was Monday, and
I thought the first 30 might have been Monday.
the first 30,
Okay.
Monday.
All right. Okay. So I honestly did not think we would. I am really glad that we did. Congratulations to everybody. Get through as much as we got through today. But given the last couple of days, I'm pleasantly surprised that we did. So I actually, at this point, told the jury, don't come before Wednesday, because I figured we had enough work to do Monday and Tuesday. And I think that probably is true. But yeah, with everything that you're, and if y'all get finished early, you don't have to wait till Monday morning. You can go ahead and email whatever you get finished with as you're finishing it. All right. So yeah, we can start working on all of that. All right. So this is a good time to adjourn for the day, or do we have other things we want or need to take up right now?
There may be one more thing that we can
Okay.
take up if the court would allow us one more.
Your Honor, we do have the 5 jail calls that we intend to get in through Mr.
Perfect.
Copeland.
Yeah, we can do that. Okay. And I've already listened to the portions of.
And there were portions that we did not object to, Your Honor, so I can go through by call which one we didn't object to.
So you're working off of, so I know that Mr. Shart had provided kind of June 19th-ish, his proposed redactions, right? Is that what you're working from to tell me which ones you agree to?
Yes. Is
Okay.
that what Mr. Steele sent? No. For the jail calls, I'm looking at Wednesday, June 26th. There was an email that Mr. Steele sent.
I don't know that I have that.
Okay.
What I've got is it may be the same list. Oh, it may be. I don't know. What I have is whatever Judge Glanville had made a court's exhibit when y'all were talking about them. And it says forward, Stillwell proposed redactions. Anyway, it's a list of like 10 proposed redactions. Is that the same thing when we get down to it, or?
No, I have.
Well, give me what it is that I need to be looking at.
I can find it for you.
You know what? What I'm looking at right now is not even about the jail calls. So never mind. But I don't have what it is that you're talking about.
I'm looking.
So there are
I just
5 jail calls and there are portions of the 5, is that right?
Yes.
Okay. And then you have agreement as to certain portions of those? Okay.
Yeah, so the
All
state's
right.
intention was to play the entirety of the calls, but
All right.
then there were some objections, and so
Sure.
we don't have any objections.
Okay.
We don't have objections.
All right, so do you want to put on the record what portions?
As if the court has the email, I can go through the areas where there was objection. And
I don't have the email. I do have the email. I just don't know where to find the email. Okay. All right. All right. I am now looking at the email. So go ahead.
So for the first call, which is on March 11th, 2015, there's an objection from 10 minutes and 45 seconds to the call to 10:50. The state has no objection to not playing that portion of the call.
Okay.
From 15:15 to 15:32, the state has no objection to stopping, to not playing that portion of the call. For the June 10th call, from 7 minutes to 7 minutes and 3 seconds, we have no objection to not playing that portion.
Okay.
From 8 minutes to 8 minutes and 12 seconds, we don't have an objection. And from
Okay.
9 minutes and 57 seconds to 10:15, we do not have an objection.
Okay.
For the June 13th call, we do object to that portion of 2:55 to 3:10.
Okay.
June 14th, we have no objection from 13:51 to 13:58. No objection from 14:11 to 14:13. And then for the June 15th call, we have objections to 4:53 to 5:11.
As in y'all want that in?
Yes, you're
Okay.
right. 6:01 to 6:12, we object. We want that part in.
Right.
6:42 to 6:49, we want that in.
Okay.
But I don't know if someone told me this, but I wrote in 13:10 to 13:17. And we don't have an objection to that part. I'm not sure if maybe someone called me, but I wrote in another portion of that call, and we do not object to. Oh, that's on the email as well? Okay. I wrote it. I have it handwritten.
Okay.
So, because it's on the back side.
All right.
So we have no objection to 13:10 to 13:17.
Okay, great. All right, so then our issues are with June 13th, 2:55 to 3:10. And then June 15th, 4:53 to 5:11, 6:01 to 6:12, and 6:42 to 6:49. Is that correct?
Yes, Your Honor. And so we're pulling those 2 calls up now, Your Honor.
Okay.
You have me live?
As Mr. Box is here and Mr. Steele is handling this portion, may I step out for a
Sure.
This is a free call from.
And I'm going to start, Your Honor, around 2:25.
He booked the Brady. Meet me on University. On University where? At that gas station we always. You know what that gas station? Chevron. That's Chevron. Meet me at Chevron.
Hey, man.
Okay.
Yeah. Look, D ain't right, bro.
What did D do?
I'm gonna say too much, bro.
The D told. What's that?
You talking about rock crew, Lil D?
Yeah.
I told him. He told on Roscoe too. You think I'm fucking playing, bro? He told on Roscoe. He told on Roscoe just how he Roscoe ain't no fucking blood. And he don't give a fuck. Roscoe ain't free. Hey, D trying to come up and come meet you.
And that concludes at 3:11, Your Honor. And to give some context, on this call, this is a call from June 13, 2015, which is 3 days after that June 10th interview. Mr. Copeland is now in custody. He calls his girlfriend, Miss Quarterman, who then calls the person who you hear is Max, but is also Dolly White, also known as Dolly White, but is Mr. Williams' sister.
Mm-hmm.
She is a person that the state alleges a number of the gang members will call to get in contact with Mr. Williams or for her to facilitate a number of different things throughout the trial.
Mm-hmm.
And while on the phone, there's first talking about money to help with his bond. That's when you hear her talking about meeting the girlfriend at the gas station.
Right.
Then he says, little D ain't right. At that point, they jump to, because he snitched, because he told on Roscoe, and they're talking about him not doing what a gang member is supposed to do, which is then snitching, Your Honor. So we believe that that is relevant information for this jury to hear, that the gang members are talking about the failure of another gang member to be supportive of the gang, to actually tell or snitch on another gang member. And that's what's contained in that portion of the call.
Okay. And the objection.
Hearsay, Your Honor, it is not, I don't know, I've listened to these so many times, I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like, this is inappropriate for a gang member to snitch on someone. That's not in there. What he said is, something to the effect, I'm not quoting it, hear what little D did.
Yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah, so how does he know that? Who did he hear it from?
Well, I don't know that that matters, because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering whether D is or ain't right. It's the fact that literally it was everything they said about him, and overtly the fact that a YSL member they believe told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
And do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent for the government. He is being told on June 10th, you need to work with us, otherwise you are going to get severe time. And he says, great, I will work with you. That's in the recording that you listened to. You didn't listen to that part, but it's in this 9-hour recording. So I don't see how this comes in. It is hearsay that he is just saying, did you hear with this other person? We have no idea the context. And it is being asked for the truth of the matter because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we can ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you can think of.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
If they lay a foundation, then
And I don't know what that's going to be, but assuming, I mean, I don't know. Maybe you want to elaborate, Ms. Hilton.
We believe this is also evidence of the overarching gang conspiracy. Again, we have to prove that this is a conspiracy, that this is in furtherance of that conspiracy around. We believe that one YSL member telling another YSL member that one YSL member snitching is in furtherance of protecting the conspiracy, protecting the gang, Your Honor. And this would be evidence of that. So essentially it would be a co-conspirator statement between these co-conspirators talking about gang activity.
I mean, I think if the proper foundation is laid, that comes in over a hearsay objection. Okay, and then, excuse me, June 15th, a couple of different portions.
Your Honor, of course, I would just start at 450 and play through 649 because it's only about 2 minutes for those 3 sections.
I'm still sitting on the phone.
And tell me who I'm about to hear.
Yes, Your Honor. And Counsel, this is again Mr. Copeland calling his girlfriend on three-way, but at this point he has asked his girlfriend to call Detective Gaither. And so the portion that you're hearing is Mr. Copeland and Detective Gaither on the phone.
Okay.
I'm going to start at 447.
Everything. Like, I'm not going to sit here and promise you, like, you're going to get out of jail next week or in 2 weeks. All that. Like I told you, you gave us a lot of good information, but we got to still do our job. We're not just taking your word for the gospel just because it's coming from you. We still got to investigate shit. So all of that will be taken into consideration at the end of the day. So
my brother,
like I said, do your brother know what?
That set up for the feds could touch him.
I'm not talking to nobody about your case, but to you and who you got on the phone. Yeah. That's up to y'all. Like we don't do that.
I'm saying, so is they trying to work with me though? Is they gonna try to work something out?
I can't say what they gonna do. Like I said, everything that you told us, we want to speak with you again. All of that will be taken into consideration. That's what she told the ATF agent when we first came in, the lady.
Yeah.
That's what we did in the beginning. A lot of what you say will kind of determine your future. That's why you need to be completely honest with stuff.
Yeah.
So at the same time, we still got to look into it. We're not just going to take your word for everything you say. We got to be able to, prove what you say is true.
So if I prove it, then y'all let me have it right.
Are you hearing anything that I'm saying? Because I feel like I'm talking in circles.
Nah, I hear you, but it's confusing.
If you provide us with some things that we can verify, it's not up to us to let you out of jail. That's totally up to the DA's office, all that stuff on what they want to do with you. They do take into consideration if you helped or not. And so far, it appears as if you've helped, but we still have to do our job and investigate.
Yeah. So I still got state and the.
And I conclude at 6:53.
Okay. And so what is at issue? What statements specifically are at issue?
Detective Gaither's statements, bolstering so far. You've helped. We still have to corroborate, but so far this was helpful. I don't know what the right word is. And I believe that that's bolstering his statements.
All right, and what does the state say to that?
Sure. Yeah, we don't know what he's going to say on the stand. But if he goes down the same line of, I was just lying to finesse investigation, I made it all up, this is in complete contradiction to that, because she's telling him, just like she told him in the interview, we have to verify what you're telling us. So if he was telling lies, he wouldn't continue to say the same things over again, because she keeps telling him, everything you told us, we appreciate you telling us, but we have to verify everything that you said. So there's nothing I can do for you until...
Well, he's not really saying anything over again. He's saying, hey, I told y'all something. Can you let me out now?
Right, and so when she's saying, he's saying everything I said is a lie. So
he is now, yeah.
He is now. So what this shows is a contradiction, because he wouldn't be calling the detective trying to continuously see if he can get out of jail if what he said was a lie. Especially when she's telling him.
All right. The objection is that Detective Gaither's statements, you know, well, yeah, I mean, you seem to have helped us, but whatever. Why do you want any of this in?
Well,
how do you envision using that particular thing I just heard?
So there's a few things. So part of this trial, some of the defenses that have come out is that the police didn't fully investigate anything.
Okay.
That they took his version and just ran with it.
Okay.
So this supports that that's not what happened. That even back in 2015.
Is Detective Gaither going to testify?
She has testified.
All right. Has she said already, man, we didn't just take his word for it, we investigated?
She testified
Yes.
to that.
Okay, so it's not necessary for that.
But again, I think it gives context to, while Mr. Steele's focused on Detective Gaither, we're focusing on Kenneth's actions, that if he lied, he would not continue to call the police to verify how they're going to help him. When he knows, listening to Detective Gaither, every time she speaks to him, she says, we can't do anything yet until we verify what you told us. So clearly what you told the police isn't a lie. Even though you're saying that today in 2024, what you told them back in 2015, you believe to be true, because you wouldn't keep calling if you just wanted to tell them one lie and that was it. You wouldn't keep calling the detective.
All right. So let me ask you this. If what you want that in, or those portions in for, is Mr. Copeland's, hey, y'all, come on, I gave you the truth. Let me out now. Is there some way that you could redact that where we don't hear big chunks of Detective Gaither saying something she's already said on the stand anyway, which is, I got to verify this stuff? See what you can do, okay?
We can see what we think will be out of
Well,
we'll see.
I don't know.
Judge, if I may.
Yes.
Again, putting everything in context and thinking back to some of the testimony that Mr. Copeland had put forth previously. You know, the state's position that he just put to the court as well. If he wasn't telling the truth, why would he call and try to follow up and see if they were checking on his truth or not? When he testified, one of the things that he said, it was probably the biggest thing that he said is, hey, they don't know that I'm lying. And he said, yeah, I lied to them. I'm trying to finesse my way out of this, but they don't know that I'm lying. And that was in response to a specific question that Madam Prosecutor, Ms. Hilton, asked Mr. Copeland. So I think that kind of, that goes against what they're saying as their rationale.
I mean, don't get me wrong. I'm not sure that what they're saying it's going to come in for is going to in any way show or be a convincing argument, but I mean, they can. Yeah, it's not inadmissible for them to try it.
No, I understand. But I think our objection, as Mrs. Steele stated a little while ago, is, why is any of what the detective's bolstering of Mr.
I understand, which is why I told her if she can come up with a way to get her part in without the objectionable part, she needs to try to do that.
I'm confident that she can.
Let's have it. All right. Okay, so that is all of the jail statements.
Yes.
Okay, super. All right, one thing I wanted to do is do some test run of this, and this doesn't need to be on the record, where I just don't have it. I've never used these before. So how is it that y'all are doing this? Do I hand these out to all of y'all and then? All right, I don't need to, y'all have them, so.
Well, no, we need the base.
Okay, and I mean, everybody doesn't have to do it. If a couple of people want to. No earthly idea. It's plugged in right now.
Okay.
So I take one of these too. Is there some significance to the red ones?
You want one to try?
Hey, is there some significance to the red ones? Does anybody know whether there's some significance to the two that are red?
I don't think you've ever used those.
Oh. All right, so. And does the court reporter get one so she can also hear what's going on, I would imagine? Okay. And then what?
There's a push to talk.
Sorry, y'all. Yes.
I have
We're done with court for the day, so you do not need to video me trying to figure out the technology.
that was the easiest request, Your Honor. Clarify that.
Can I make one more statement before you adjourn?
Something we need to put on the record.
Yeah, we could
Yes.
use the fetch if you want to use your
Hey, that's a brilliant idea, because they don't take pitch conferences. Sounds good to me. All right, then how do you turn what is this?
This will be
Okay.
brief, but Your Honor, important to us and to the court. On February 7th, 2023, on April 18th, 2023, September 6th, 2023, January 13th, 2023, and one more, and then, which I don't have the date, July 29th, 2024. Mr. Williams has put in Brady motions,
Okay.
and the state has not complied with Brady. They comply at times. I'd like a date certain, like today, that any Brady evidence that's still outstanding, that it has to be to us by Monday or whenever you think, Wednesday, whenever, because Brady is, so serious, because then we go out and investigate, but the witness is already on the stand.
Right.
So I've, I know I don't have to put in writing. It's not good faith or bad faith. It's a prosecution team. But if the court can just set a deadline, and then obviously it's ongoing because new information may come forward. That's my only issue.
Okay. Is there anything that you, know of that you don't currently have?
No, because then I'm not so sure it'd be Brady.
It wouldn't be, but people refer to stuff as Brady, even though it comes out and you have it for the trial.
But anything, Mr. Zachary is a perfect example. I have no evidence of this. But if he's coming to testify, the state has alleged that he's a co-conspirator, unindicted. There has to be some sort of agreement. I mean, there just has to be.
I'm sorry, some sort of what?
There has to be an agreement.
An agreement. Oh, okay. Well, a lot of times there's not any agreement.
Okay.
There might be.
But
I would
let's use that as an example.
I would hope that the state knows that if you have an agreement with any witness about, you know what I mean, more lenient treatment, any kind of an agreement, that you need to reveal it. You know that, and you will do that. And you will do it as soon as you know it. If one does not currently exist, but one develops next Tuesday, then tell the defense next Tuesday.
We will.
Okay. And as to any Brady material, and understand your obligation is to everything you know right now that is material, potentially exculpatory, anything that could be covered under Brady, you need to provide to the defense if you have not already done so. And I'll let you make a statement if you would like to after I finish talking. And the Brady obligation is continuing. So if y'all are still doing any kind of investigation, you come up with anything that is Brady material, then you also need to get that immediately to the defense.
Yes, we understand that.
Okay.
And
All
we
right.
will continue to comply, and we will converse. And if there's anything that either team member is aware of that we need to provide, we'll provide.
Okay. Thank you.
Thank you, Your Honor. Thank you.
All right. See y'all at 8:45 on Monday. 9 on Monday. Yes, Mr. Short. Let's say 9. Y'all did such a good job today. I'm going to give y'all 15 extra minutes to sleep. 9 o'clock on Monday. Yes, sir.
Your Honor, I just wanted to bring it to the court's attention that I know that Mr. Weinstein has an outstanding motion that he renewed maybe 48 hours ago.
Which was...
You might know about my mistrial?
Yes.
Oh, no, I know. He has a supplement to that, and I thought I said this morning that's what I'm going to be working on this weekend.
And I have some bad news for you.
What's that? You
as
have
we
more
head
to
into the
add?
week. Yes, Mr. Weinstein's a faster writer than I am, but
He is a good writer.
He is.
It's very kind of you.
Welcome.
So I recently filed while we were in court, a motion for a fair trial seeking remedies. Oh, and I will email, it was just filed, and I will email it over. Mr. Steele brought up the desire to have an evidentiary hearing on these matters. I know that
which matters?
The ex parte communications and the impropriety.
Yeah, like wanting to cross-examine the... Oh, yes,
Calling
wanting
John
to
Melnick.
put Mr. Melnick's testimony. And yes, I had said that you could give me a proffer, and if you're ready to do that, we can do that.
Well,
Y'all don't want to do just a proffer.
Mr. Steele was the spoke to Mr. Melnick, but yeah.
Okay, all right. So with regard to the motion, Mr. Shart, that you filed within the last few hours, if you could email that to Ms. Persifield, I'll take a look at that over the weekend as well. Mr. Steele, if you want to be heard on I'm glad. Thanks for the reminder to circle back on that. I had said, talk to Mr. Melnick and you can put a proffer on the record. So if you're ready to do that, we can do that now.
I need more time because I did speak with Mr. Melnick. I told him what your Honorable Court said. He stated that it was very nice. He said that I does not get any permission for him. He'd like to address the court himself. Okay. That's what he told me. So I can't make a proffer because I don't have the information. I have him under subpoena, like I told you.
Okay. What do you have him under subpoena for? When?
2-hour call. 2-hour call.
Okay. Well, can you proffer to me? I know you can't say, here's what he would say, but how about tell me why it is that you think this is something relevant to this trial at this stage, considering that Judge Glanville has already been recused. And maybe y'all want me to, I have not finished reading all of the material and all of the case law, so I don't know what my decision is going to be on the supplemented motion for mistrial that Mr. Weinstein filed on behalf of Mr. Kendrick. Do y'all want, I will rule this weekend. Do you want to wait and see what that is? Or do you want to just tell me why is it that anything Mr. Melnick might have to say in defense of himself matters for the trial? It might matter for everybody's, what they feel about their professional reputation. I get that. But for this trial, why does that matter?
So, under Carr, C-A-R-R versus State, it's a 97 case, 98. It was the case that the gentleman owned Heights Nursery, I think, the house burned down.
Yeah.
There's great language in there about prosecutorial duties.
All right.
And it talks about that the prosecutors need to they carry the burden. They can charge people. They can ruin people's lives just by the charge. And they have a duty to the public to be open and candid.
Sure.
So, and all lawyers do, but especially prosecutors. And Mr. Melnick, I know this because he did say this, and that's why he wants to address you, because he was not mad at me. He said he needs to have it on the record himself, because he said that what the state was saying is not accurate.
Okay.
And I think that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate, and I'm not picking anybody, but like the Honorable Judge Krause said, if I was going to ask this Honorable Court for an ex parte meeting, I believe that the way I always have it is there's a buffer. You have somebody say, what is it about?
Yeah.
I tell you, and I have to be candid. And if I'm not, in hindsight, you would probably, I assume, or any court would tell me, you had no right to do that because you got it with false pretenses.
Okay.
Mr. Melnick is going to say that what Adrian Love said to the judge is just patently not true. Via emails, or description of the emails is untrue. And there's no way to say that's inadvertent, because she said that on Friday the 7th versus Monday the 10th, she kept talking about these emails and she changes her statement. So anyway, I believe that it's...
All right, the best evidence of that would be, I'm sorry, I didn't mean to interrupt you, but just somebody give me the emails.
I did. I put it in my motion that I filed when I found out this Honorable Court was the court. And I forget what I titled, I can find out for you. But
Okay, I'll go back and look at those.
it was a motion, it had 2 parts to it, and it said, I really don't want, and I told you, I don't want a mistrial. I just want to make it right, and I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you'd make a credibility determination, Adrian Love, John Melnick's statements. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege, but he's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off, so it's not in the transcript, so Mr. Weaver's either not there or definitely not recording it, that Mr. Copeland did talk about the killing of Donovan Thomas, said it's not on the transcript. And that would be either Brady, if it's an inconsistency.
So wait, so that I understand what you mean. You are saying that you have reason to believe that in the June 10th ex parte meeting, once Mr. Copeland was a part of that he talked about the killing of Nutt at a time when Judge Glanville was in the room? Because there were definitely two different portions where at one point he and Ms. Bumpus talked privately, which obviously nobody recorded because the court, at least the record reflects the court reporter and the court and whomever left the chambers so that they could talk privately. So it's entirely possible he talked to her about that. That wouldn't be on the record and it shouldn't be on the record. Nobody else heard it. And then there was another portion where I believe the court left so that I don't know if it was you, Miss Hilton, or I think Miss Hilton, Miss Bumpus, and Mr. Copeland could talk together.
That's the part I'm talking about. So it's not privileged.
Okay. All right.
That there was substantive conversation about the killing of Mr. Copeland.
Okay. So
And Miss Hilton.
hang on. I'm jotting some notes for myself. Give me just a second. All right, and you have reason to believe that whatever Mr. Copeland said at that point in time in front of the prosecution is something that is Brady material.
Impeachment.
Okay, impeachment. Okay, and therefore Brady. Okay.
So that's why I wanted to put.
All right, thank you.
And call the prosecutors. Now, they may say that didn't happen. And I assume that's what they're going to say because they would have a Brady obligation to run out and say, in June, this happened, this man said this. But they didn't say that with anything. So I don't trust that the Brady was being complied. That's why I asked you again today, please, can you put some teeth into Brady? Because Mr. Copeland did say on the record, I'm a liar. That is Brady. That's like the greatest Brady.
Well, you got that, so.
But I got that because.
I know, but you have it now, so it's not Brady, just like you just said.
But my point is, it was hidden on the 10th. How about that? By Judge Glanville and the prosecutor. They knew about it because they were in the room when that was discussed. That's objectively true. So anyway, I'm just telling the court, I was not there. I don't want to make specious allegations against anyone. That's why I want to get it right, and that's why I asked you to have an evidentiary hearing.
Okay.
I believe that there's Brady evidence. I have a good faith belief. I'm telling you everything I know. I'm told that it's not privileged that Miss Bumpus, Miss Hilton, Mr. Copeland spoke, and it's not in the transcript, and Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved.
Mm-hmm.
He has himself learning about from another person.
Right.
And my understanding is that is not what he said. That's inconsistent on June 10th, and I did not get that from Ms. Hilton. If that's wrong, but I can't ignore what I'm being told.
Okay, well, that's new information for this court, so.
That's what I wanted to call the witnesses because.
All right, well, you didn't tell me that before.
Okay, well, I didn't mean not to tell you that. I'm trying to be open, but that's the reason I wanted to call the witnesses.
Okay, I mean, that's, okay.
additionally, Your Honor,
Yes.
at some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte communications.
Oh, I know. That's a
And-
part of Mr.
Right.
Weinstein's motion for mistrial. Yeah.
And you know, I don't want to be a witness. I mean, I could say that there was absolutely no reason for it, and there was no cause for the state to even have these concerns. But Mr. Melnick can explain, you know, if he was conspiring with me and Mr. Steele to obstruct justice, I doubt he'd want to come in here and talk about it, but the state can ask him about it and get to the bottom of it. But I don't think that's what the testimony is going to be. And I think that's important for the court to know.
Okay. Well, I don't know that whether it's true or not is what matters. It's what it looked like at the time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up, we're going to do some research. We'll get back to you. And by the way, y'all, I know that everybody, whenever we were here last, was that yesterday or the day before? Wednesday. So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte, because people from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out to be.
Can I respond to that?
Yes.
So, as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting immunity. Little did we know that they had already done that and they were going back there to have that other conversation. So that's
okay. Yeah, I mean, I know y'all didn't know the substance of it, but.
And wrapping back around to that.
Yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that occurred as a meeting, because I told everybody on Tuesday, stand up and tell me anything there is. Did y'all do anything beyond the motion to get the immunity order for Mr. Copeland?
No.
Okay.
So we submitted a motion.
Right. And they have a copy of that, and that's,
Right.
all right.
Right.
Okay.
That was,
Okay.
and Judge, I'll also state that at the time, I'm not certain why it would be believed that we were trying to get the warrant or the immunity agreement because Mr. Copeland was under arrest at the time that we stood up and made that announcement in court on the 7th. I think he had already been arrested, I think.
You could be arrested and not have immunity for your testimony.
The judge had already told him he had immunity on the record.
Okay. Well, I don't know. I mean, they're probably just trying to remember it themselves too, but. All right. Well, Mr. Shard, I'll take a look at your new motion. And obviously I'll be looking at Mr. Weinstein's motion. And why don't, Mr. Steele, you plan to have Mr. Melnick here at 9-ish. I don't know whether I will hear from him or not, but okay.
And Your Honor, so that we are, I'm understanding is on Monday, we're having the matter that Mr. Steele wants to present Mr. Melnick for.
Maybe.
Would that be a collateral issue?
Maybe.
Okay. So
if I end up hearing from the two of you on that, I'm not gonna make you not be prosecutors in the case anymore. We can hear that separately if I even hear it.
And so would Mr. Steele be allowed to introduce extrinsic evidence of a collateral issue that he's raising about the emails and things of that nature?
I mean, the emails are already in the record. I think he's complaining that at one point, I mean, the emails are what they are. And at one point you said, this was an email to me. And at another point you maybe said, I accidentally got copied on this email, but I think it's actually different parts of the email. I think there's actually an explanation for why that might sound inconsistent, but I'll go back and look at all of the transcripts. But beyond that, I mean, no, I don't think so. I don't know what he's got planned. Maybe you want to ask him, but I don't know if he's talking to you yet. So I don't know. We'll take it up Monday. All right.
One last thing, Your Honor. On Tuesday, I believe I brought to the court's attention whether or not the court would allow, if we get to Mr. Copeland next week, I know you said the jurors might not come back until Wednesday.
Right.
Substitution of counsel. And wanted to see if the court had made a decision or a ruling. Objection.
Yeah, I never got any kind of written anything or further objection from anybody. So I think there's just the one objection that I didn't get a real good reason for. Okay. Yes, there may be a substitution if we end up examining him while you were gone. Thank you, Mr. Weinstein. All right. We're actually in recess now.